Hi, everybody. I'm welcoming everybody back. It's nice to see some of the similar attendees on the calls that you guys have been attending all the way through. So I'm pretty excited about that because it's like hopefully you'll understand this entire process by the time that we're done. And for those that are just joining us, hopefully you can watch our other webinars prior to this and continue to watch our series. So again, I'd like to welcome Matt Trotta back from Field Law on talking about how he works with the job and how he works with us.
Oh, thanks for having me.
Excellent. So Jeff, I think you're going to do a poll starting off.
Absolutely. So thanks, Pam. So it's Jeff from the Tower Group. I'm just going to jump into a poll here. You're going to see it pop up on your screen. Just answer the questions and we'll share them with the group. So the question is, how many of you have your vehicles jointly registered? All right, we got some votes coming in. About 70% of you have voted, at 80% now. Anybody else? Going once, going twice? Okay, let's share the results on the screen here. So 57% of you said no, 43% of you said yes.
Wow.
Interesting.
So this will be something that we're going to be discussing today and also in our next session next Thursday of how important this becomes in settling this estate. Perfect. So thanks everybody for doing that poll. And as we see, like half the audience, more than half the audience has their vehicles just in one name. So what the role, like a lot of times people say, you know, I can do this myself, or what's the role that you actually do? Because usually the Tower Group is your first call that people often make when something's happened. So I often say, you know, it's good for us too to have names of people that we know in your family, or even to meet some of your family. Some of the people we've met, kids we've met, outside family, because you know when we're getting that call at 12:30 at night from a movie theater that gee somebody's had a heart attack has been one scenario that's happened, or you know gee we've been involved with a client, you know, taking them to the hospital, or you know, helping with somebody's family when they have to go in the ambulance. That's often happened for us. So I kind of say what we do is we take on that person of actually assisting an executor. So really being an executor is a really daunting task. Actually just dealing with somebody's death or, you know, severe illness at a time is a daunting task. So people often are in a very emotional state. It's hard to think through things. It's hard to talk to people. It's often the thing where you tend to see the most emotion from people. So if you're calling somebody like NMAX, even, you know, I've had more people come in who have gotten in a fight with NMAX that day and they hate them and they can't stand them. And it's like, but it comes from the emotion of what's happening in their lives. So we often see some of our clients have actually gone through and went, you know what, I can do this all myself. I think I can do this all myself. And it's like when you're trying to deal with everything all at once, and that's exactly what happens when there's a death, is not only are you dealing with the emotion of your children, you're dealing with the emotion of family, you're dealing of the overwhelm of trying to get everything done, but all the chips fall at once. And so we often say, don't try to do it yourself, because every client that has, and we have had a few, they come back to us and they said, I had no idea this was this overwhelming. I had no idea it involves this much stuff. I thought this was easy. They get through about 5% of it and then throw their hands up and go, I can't do this. I can't do any more of it. And sometimes they've done it wrong. And sometimes the banks won't reverse what they've done. And, you know, when you look at the laws and everything of how you are to do things and how you are to keep track of things, a lot of people don't do that because they just don't know and they've never been through the process. So really important that, you know, you reach out right off the bat. We can help you through that process as an executor going through all of that. We're kind of that sounding board of stress when you feel like you can't do anymore. We're there to assist and guide you. We're there to be your voice. We're there to be your family's voice through this, because a lot of times people are crying and it's hard to deal with the emotion, and then they just look at you and go, I don't know what to do. That's what I get a lot of, and it's just they freeze up, and sometimes people just truly can't make decisions, and then all of a sudden they just freeze up. And when they freeze up, that's usually when a lot of lawyers, which Matt can kind of talk about, is when things get people down and they're overwhelmed and they can't take action anymore. It tends to freeze up the estate, and then all of a sudden they haven't settled the estate for 2 or 3 years. Isn't that right, Matt?
Oh, that's absolutely right.
So what we kind of do, and this kind of shows you how we work together with everybody. So when we look, we often say to people, never make major decisions within the first year of a family's death. And today we're going to talk about a case study as well near the end, just on a typical family, just that you guys can kind of see the process. But we go through and obviously deal with real estate agents, accountants, appraisers, auctioneers, if there's valuable property people have collected over the years, cars, paintings, horses we've seen, banks and agents. Banks are always a common one because everybody has them. Bankruptcy trustees, and sometimes, you know, that's happened. It happened to, you know, not only a close friend and client of mine, but, you know, that type of scenario happens with sometimes parents that they don't realize are in trouble. Corporate executors, credit unions, financial advisors, because sometimes people have things in multiple places. Funeral directors, lawyers, life insurance people, mental health counselors, and life insurance might be group, which we'll talk about again with that case study. Mortgage lenders, paralegals, and that's like Matt's assistant that we deal with there. Planned giving officers, your personal insurance, and of course, we'll get back to the real estate agents. So what we can't do, and a lot of people ask this of us, is can we be your executor? We can't be your executor and a certified executor advisor to help the executor and look after your money. That's a complete conflict of interest. So we can't be your executor, but we can help your family settle everything you do. And that's also why we work with a lawyer, so that he can stand by us and help us settle your estate. We can't act without you. A lot of people kind of throw up their hands and go, I've had enough, I can't do it anymore, I'm tired. You know, we then have to wait for you to come back. So we can't do it all for you. We can do some behind the scenes stuff that you've already authorized, but we can't start moving things ahead without you. We can't file your tax returns. So we often get a conversation with people over the years of, why do we use an accountant? Why do we pay an accountant when we can do quick tax online? Try to do your own estate quick tax file will be really interesting, and 99% of people in my 21 years, 22 years of experience have done it wrong. Every single time, there hasn't been one person who's done it right. So again, that's why we work with professionals, because they also know your situation and they know what they can claim. They know that they can do some losses back, or they can carry stuff backwards or forwards. A lot of regular people don't know that, and quick tax videos are not going to tell you how to do that. Giving you legal advice. A lot of people are like, well, I can go down to the courthouse and do it myself. Certainly there's things you can do, but there's a lot of stuff you can't do. And there's a lot of stuff that you could run into problems doing. And then if you have to find litigation, trying to get support for all the things that you've done is going to be a lot more expensive and a lot more ugly for you. So again, that's why we involve the lawyers right up front with all of our clients. We value, protect, can we value, protect, control, transfer, or make deals with friends or family for real estate? So I've seen this in almost every estate that we've dealt with, as people go, well, can't you get a value? Can't you get somebody you know to try to get me a value? And I'm like, well, if they're a realtor or evaluator and we get proper studies done, yes, we can do it. And they're like, can't you just give me a number? No, I can't. A lot of people have asked if I can go sit at a house while they go to change the locks. No, I can't do that. And things like, a lot of times people are like, well, I wanted my house to go to my kids, and I wanted them to get a special deal where they buy it for this or this or this, and it's after the fact, it's not written up anywhere properly. You have to transfer assets at fair market value for an estate, so that it becomes the problem that you might want to sell your house for $1, but you really can't. And then ignoring instructions, of course, to do something illegal or fishy. And when I come up against that, usually we have to shut it down and give it to lawyers, or we tell people up front, this isn't the time to try to be greedy, I guess is the best word that I can use there. Is a lot of times people are like, well, I don't like that person that was in this will. I don't want to give them $20,000. Can't we just, go around them? Can't we have to donate this money to somewhere else? Can't we, work around this? Or can't we take money out of his company to do this? You can't do things that you just can't do. And I know it's a lot of times people would like to, but I think that's something that's really important to look into with that. And I know, Matt, you've probably got way more stories than I do.
Oh yes, that comes up an awful lot. So where do we come in an estate administration? Well, the primary role of a lawyer is to do exactly what you would expect a lawyer to do: provide advice, counsel, and information. This may be for the personal representative or executor. This may be for one or more beneficiaries, depending on the situation. And we would advise on all matters in connection with the administration of the estate. This would also conceivably include any testamentary trusts that arise out of the estate. And this may, in some circumstances, be a different person acting as trustee. So there may be conceivably counsel for that special trustee as well. The main task that we do in each and every instance is do an analysis of whether or not we need to get a grant from the court. What the grant is a legal verification of the right of the personal representative, if there's a will, or administrator, if there's no will, to be able to act on estate assets. And it's always necessary when we're dealing with land titles, and almost always necessary when we're dealing with bank accounts and registered assets and securities. There may be cases where a bank account is small enough that there may be an exception that a bank can make, but that's an exception that they choose to make and not an exception that is in statute that they have to make. So there are situations where you can apply without a grant or administer without a grant, and that is usually in a situation where it's the first to pass away spouse and everything is jointly held. In all other cases, we're doing a grant of probate if the will exists, a grant of administration if the will doesn't. One that you may hear that comes up an awful lot with defective wills is a grant of administration with will annexed. So this is usually if there's an incomplete will, if there's a deficiency in the will, such as the two that come up the most is there's no named executor, or there's a gap in the gifting of the will, and there's a gap has to be filled by statute. Another one that comes up a lot with clients who have assets in multiple jurisdictions is a limited grant. This may be a resealed grant if somebody has already applied primarily in another Canadian province or the UK or the Commonwealth, or an ancillary grant if they originally applied in the United States or another foreign country that isn't covered by resealed grant provisions. What else do we do in the administration of an estate typically? Well, we'll typically prepare what we call an advertising for claimants. This is important because it sets timelines for when somebody can commence an action against the estate for unclaimed unpaid debts. I say claimed because sometimes people come out of the woodwork with BS. But one way to make sure that we're certain is we apply by advertising in a local newspaper, one that gets reasonable circulation in the jurisdiction where the person passed away. This is one of those things that we're probably going to see be replaced with some other means because the newspaper is becoming less and less useful. But for now, this is how we do it. We advertise twice. If nobody comes to us within 60 days, then there's no recourse against the assets that are distributed or used. We also will prepare documentation for transfer of stocks, shares, bond, real property, or other property transferable under the grant. Best example of this would be If we have property held in joint tenancy, we'll facilitate the transfer to the surviving spouse. If there is no joint tenant, then we will transmit the property in the name of the personal representative or representatives so that they can deal with the property and properly sell it. Since technically in a real estate deal, you shouldn't be signing a contract to transfer the property unless the property is in your name in your capacity as an executor. This often gets missed, and this often creates a lot of problems because, to be candid, realtors don't care. They're looking for the sale, but an executor should care each and every time because it's them who are warranting on the contract that they're ready and able to close. We'll also act as counsel for any non-contentious or contentious estate matter. Non-contentious might be advice and direction if there's a provision in the will that's deficient or vague. It may be a formal proof of will. This may also be a contentious application, but this may come up if we have more than one will that may be valid. There may be a question of whether or not the wishes on the back of a napkin are scrawled onto a tractor. There's case law where that happened, whether that's valid. And it may be to cure deficiencies in a will, such as if there's typos or if there's issues that we have to speak to. Contentious estate matters are pretty obvious if we have a situation with undue influence or suspicious circumstances. Somebody's questioning the integrity and actions of an executor, things of that nature. Often this may not be the same estates lawyer who is administering your estate, because sometimes it may require a specialist litigator depending on the type of matter in question. If, for example, it's a question of a trust that arose or is deemed to have arisen, you may have a litigator who's specialized in that. If it's a situation with a corporation, then you may have a commercial litigator stepping in on that as well. We will also advise the personal representatives to prepare and file tax returns. Important distinction here is advise and not actually prepare or file. In almost every instance, a lawyer will not do this. You may have the odd situation where you're dealing with somebody like me who is an estate and tax lawyer, where we might file certain forms or make certain applications to CRA, such as taxpayer relief, if there's a situation where there were penalties and interest accruing that were outside of the control of the executor and other factors applied. But in almost every other case, we're not filing T1s, T2s, T3s, or anything like that. We will also submit financial statements, and again, we say submit because it's not often that a lawyer will agree to prepare financial statements. That's the job of an executor with the use of financial planners, analysts, and accountants, bookkeepers. But we do submit, we'll review, and we'll circulate for beneficiaries and deal with the issues that may arise from that. We prepare releases and acknowledgements for interim and final distributions to make sure that beneficiaries understand the conditions of interim distribution or understand that there's the final distribution. Conveyance of real property is something that we do. Again, this may be a different lawyer than the one that does your administration, just because not every lawyer does real estate law, just like every real estate lawyer shouldn't do estate law. Different expertise. You may have the same firm doing it, but it may be a different lawyer. Post-mortem tax planning and papering of relevant transactions is one that pops up a lot, especially if we're dealing with private corporation shares. If we've got charitable giving, we've got clients with beneficiaries that have illnesses or disabilities. This will often be a different lawyer as well, unless the estate lawyer is also a tax lawyer, and even then, they will tend to bring in specialists depending on the nature of the work that's required. What's become an evolving part of our practice over time is to not just be purveyors of legal information and advice, but also to be advisors along with CEAs and others. And we may facilitate and attend at family meetings for dealing with the transfer of wealth and responsibility, and dealing with the issues that come along with succession. This has become more and more of an important part of dealing with a lot of estates, because in a lot of situations, a lot of litigation arises from where you have somebody who doesn't understand what's going on with the estate, and the lack of knowledge leads to frustration. Frustration leads to resentment, and from there we enter into litigation. So this is something that we do in advance. A lot of times when we have a relatively harmonious situation, we'll sit together as a group. We may even sit together as a group if it's something that has an emerging issue, because it's better to deal with it in that sort of situation than to deal with it in litigation. Even with litigation, we're starting to see more and more pressure from the bench, from the justices, to exhaust the idea of mediation and arbitration before commencing estate litigation. So this is more and more of a role that lawyers are taking, and you may see a third-party lawyer acting as a mediator between the two parties as well. So from there, what do we not do? So similar to what Pam had mentioned about CEAs, we don't act as decision makers. That's the role of the personal representative. Now, of course, sometimes lawyers may be appointed as personal representatives, but then the role is different. Then the lawyer acting as a personal representative is acting as a personal representative. So in my experience, when I've worked with lawyers who have acted as executors, another lawyer acted as counsel for the estate, and that lawyer instructed the lawyer acting as counsel, and they didn't do any of the legal services themselves because they're acting as executor. Other than that, we will bring you options, we will help you weigh the decisions, but the decision making is the executors alone. As mentioned, we don't file tax forms or returns. We may file something like a clearance certificate or a taxpayer relief application, but again, that's if the lawyer is a tax lawyer as well and understands the forms, and if the situation is such that it makes sense for us to do it, because to be perfectly candid, we're more expensive than accountants to do these things a lot of the time. So it's usually better for the accountant to do it. They can roll it in with their forms. They've got the better software than we do. They'll be able to do it more efficiently. Now, if we have a bookkeeper or an accountant on an estate that's an absolute nightmare, it may be better for the lawyer to take on that role for some of the more specialist filings if that person isn't competent or efficient in doing so. But most of the time, we're going to be, when we're involved in these sorts of things, we try to make sure that there are recommendations for accountants who are specialists in this area or are from firms that do this all the time, so that we don't really encounter that issue. Lawyers also don't offer investment or financial advice. We're not insured to. We shouldn't be doing it. Even if we understand, what we can do is we'll advise on the types of investments a trustee or an executor can consider. But but if it's hey, should I invest in this ETF? Should I put it in this sort of thing? The answer is always going to be from us. Talk to your advisor, because we can't give that information out. We just aren't trained for that properly. We won't do a determination of the nature and value of property and debts. That's the role of the executor. It's a judgment call of an executor in many ways. What we do is we assemble the information that you provide, we critique it, we look for holes, we prepare it in a way that it can be reported to the court. The reason we say it's a judgment call is because when we report to the court, we report a date of death, a snapshot. A lot of times values change. The application may be done several months after the person passes away, and we may be dealing with old information. So if we say a property is worth $500,000 versus $400,000, if we say that personal effects are worth $100 versus $10,000, that's in each and every instance a judgment call. And that's why we'll advise on what we tend to see other executors do and what we think is prudent based on the information provided. But again, judgment call, executors determine. We won't make funeral arrangements unless we're the executor as well. But in any other instance, Lawyers are not getting on the phone with the funeral homes. We're not going to do these things. We're just not built for it, nor should we be making those types of decisions. It's a personal family thing. We won't protect or secure the safety of any estate property similar to CEA. There are some limited exceptions to that. If we are instructed to take action such as an application to an interim injunction or something of that nature, then technically a lawyer would be protecting the safety of estate property, but we're not going to, as Pam mentioned, go and change locks. We're not going to go sift through safety deposit boxes. Again, it's a question of efficiency, and it's a question of delegation of decision-making and judgment authority, which is the executors. We won't provide for the protection and supervision of vacant land and buildings. So we're not going to call the insurance company for you and get a new policy, because again, that's just active discretion. What we will do, and what I have done before, is if we have a situation where there's no will and we're applying for a grant of administration, and the administrator or the proposed administrator, because they don't have the ability to act until the court says they can, notices that the insurance has lapsed or will lapse, then we'll go and attend a court and get a court order directing the insurance company to take directions from this administrator. So we'll help in that sort of thing. But again, it's a we respond to instructions. It's a general rule on lawyers. We won't come up with instructions and act on our own. We won't manage estate property, including managing businesses, taking control of property or selling property. And again, this is a general rule. There may be a situation where your family lawyer may also be a director of a company or a trustee of a trust. So it wouldn't necessarily apply to those pre-existing relationships if there is that pre-existing understanding that, you know, your commercial lawyer acts as director, your trust lawyer is also a trustee to maintain the continuity of your plan. That's outside the estate. Those are different matters. But if it's something that you as an individual would control, this all falls to the personal representative. We don't apply for pensions, annuities, death benefits, life insurance, or other benefits. Sometimes that may be done by a funeral home. They may assist on that. Pam and her team may assist on that as well. But lawyers may point you in the direction of making sure that these things are done, but we wouldn't necessarily sign on your behalf and file these things for you. We won't arrange for the payment of debts and expenses, but what we would do is, if instructed again, we would deal with those things pursuant to the instructions. We won't instruct litigation. We follow our duty and our roles that are assigned to us by the executor, but we won't be able to, for example, if I'm acting as counsel for an executor of estate, direct a litigator in how they're supposed to be running, for example, Fatal Accidents Act litigation. So that would be, say, a motor vehicle accident killed the person who passed away. I wouldn't direct that without an executor directing me. And even then, we don't like to play telephone. Best way for that is the executor directly advises each professional. And if they want the professionals to talk and exchange information, that's absolutely fine. But there's a difference between exchanging information and providing instructions. Lawyers also won't distribute estate property. We will facilitate this, but we won't necessarily direct checks and whatnot unless it's a certain special situation. I had one situation where I had to accept a role as protector of an estate because the public trustee would have taken control of the estate otherwise. And so it was an undertaking to the public trustee that I had to manage the fund for the executor. And that's a very rare case, but even then, my instructions were still coming from the executor, even though it was my trust account that was holding the funds. And so from there, I believe we have a second poll.
Thanks, Matt. So we're going to pull up a second poll on the screen here. Everyone put in your answer. So the question is, do you have any friends or family that had a bad experience or didn't get what they thought they were getting when they were settling an estate? Just reply yes or no, and then we'll share the results with the group. Okay, so we're getting some pretty good participation. I have 50% of everyone locking in their votes. I have 60%. Can we get 70? Okay, I'm gonna close the polls and then we'll share it with the group. Okay, we got 70.
Hopefully not.
Can I get 80? We got 70. Okay, I think I'm gonna close the poll.
Okay.
All right, let's share the results with the group.
Okay.
Perfect.
Wow, that's actually not too bad.
Yeah.
I was expecting it to be, well, about 50-50.
Yeah. It's
so
almost the same as the vehicle, which is interesting.
This is true.
So
it's important to note, I would have thought that the number would have been higher than 50-50 in favor of yes, not because half of every estate that I've ever dealt with has ended up in litigation. I've got a much lower track record of acting as counsel for an executor on administration ending up in litigation. It's actually probably less than 10% of them have, but almost over, I'd say at least over half the time, somebody's not talking to somebody for a while after, and there's some friction. It can be as little as something as on one, there was war memorabilia and important heirlooms that there was a bit of a disagreement over, and one of the siblings took them to give to their kid instead of distributing them equally amongst all the grandchildren, and left them in a basement, and they got flooded. And most of them were destroyed. Some were able to be restored, but at the end of the day, they didn't talk for a year and a half. And like, to me, things like that happen quite a bit. The litigation, a little less so.
That's very true. So going on to our next slide, we're going to talk about Ken and Shirley today. So Ken and Shirley, they're both age 55, both kids in university. Ken is self-employed consulting company. And of course, Ken ends up dying of a heart attack in the house while Shirley is at work and the kids are at school. They have a principal residence and vacation property in BC. Insurance for both Ken and Shirley and both kids. Assets going to spouse and then 2 kids. So we often, I bring up this scenario just because of the fact that we have had this happen quite a bit. Sometimes people make it to the hospital, sometimes they do not. And the first question I get is, I can't get a hold of him. I'm rushing home. Something's wrong. He didn't show up at work today, or I'm getting calls from his office. Something's wrong. So when that happens, you can rush home, but the idea is you also need to call the police, who need to also call a coroner. So that the police have to investigate that, and the police have to attend to those scenarios. So if you are away or unable to attend the house, a lot of times we don't ever recommend sending a child home to try to let somebody in, because it's very traumatic for kids. We often end up getting a lot of grief counseling for people that need it in those scenarios, because of the fact that sometimes people have sent their kids because their kids are closest and they think that's a great idea. As long as you get authorized, the police can actually enter your home. The fire department actually will come initially and enter your home. And that's something that I often get asked, or someone's passed away in their sleep and they're like, what do I do? Should I call the ambulance? It always has to be the police, and the police have to attend. And then they usually spend a good part of the day there, and they will get the coroners to come and do their tests there. Sometimes there's autopsies, sometimes there's not, that they will arrange as they're there and do some initial testing. Sometimes that's directed by the family, sometimes it's not. It's going to depend on whether or not they see it as suspicious. So that usually is the biggest thing. Then usually people, obviously, their first concern is notifying people or notifying a funeral home or arranging a funeral home, getting their body somewhere that needs to be, which the coroner, of course, at that point will take. So usually it's directing a funeral home. So some people have funeral homes in mind. Some people do pre-planned funerals, which is great too. And as long as that funeral home's still in business, that's another one that we'll talk about. But the biggest thing is people often say, how do I do that? We've had many funeral homes and funeral directors come into our office, and I will tell you, most people are in a very emotional state. So they start with some of the most beautiful caskets I've ever seen that start at 30 some odd $1,000 for the funeral and the casket. Beautiful, and it's really great. And then, of course, the next page always, they bring in this binder that literally is this thick. I have not ever seen anyone not bring in a binder this thick. So just to give you an idea, the next page is the new cardboard boxes that are recyclable, and you can have your own recyclable funeral. And then the next page is how much that's broken down over time and how many bugs and worms, and do you want your family to live like this? Won't you rather have the $30,000 casket? And, unless you've kind of had those conversations, a lot of people even don't think, a lot of people are like, I want a really easy funeral that way. But sometimes even people getting cremated, they're trying to get a spot in a wall, or they're trying to get cremated and still buried with some of the ashes. Some of these things are something that I would say, kind of know going in what that person wants. And again, it's having those discussions. It's maybe having those discussions as part of the will, because that's something that, quite honestly, people are just absolutely torn about. And then, I've had just actually in the last 2.5 years, people who have had their spouses die. One was a lover of Tim Hortons donuts. The other one was a lover of Tim Hortons donut holes. And the funeral home, for example, wouldn't allow them to bring outside food, and that's what the person loved. And it's like, if that funeral home isn't right for your family, it isn't right for your family, and there's lots out there. There's lots of hotels that will do some beautiful things. There's lots of different venues that will do different things. But, if that's what your family's known for, is their donut holes, or they're known for some of their bars, or they're known for some of that stuff. We had one client do an amazing ceremony for her mother that, her mother loved shoes and earrings, and they did almost like this whole big party where everyone had to bring their favorite shoes and bring their favorite earrings, and she hung them all on a tree, and she hung all of her mom's stuff so everybody could look at all the great shoes and earrings she wore, and it was fabulous. And it made her so happy, and everybody talked about all the great things and how stylish her mom was. And same with the donut holes. And one, we got all the donuts for the other ones, to have it delivered as a surprise to the hotel, because they were afraid the hotel wouldn't do it. And oftentimes, when you're spending a few $1,000s, you can often, when people are emotional or they don't talk to hotels all the time, we arrange events, as you guys all know, at hotels all the time. So it's very easy for us to have that conversation with them and say, we're bringing donuts. It's better to have those conversations and making sure that that looks after your family. But then from there, obviously we go to look into, where is everything? Where are all the assets? Where's the will number one? Then we make the phone call to Matt and we say, okay, here's the will. We often, because of the fact that there's a home here, there's a vacation property in BC, there's securities, there's mutual funds, there's also group plans likely. With the consulting company that he may have had something set up through his company. So it's like, what do we all have set up? What is there for assets? What is there happening? What's the house worth today? What's the mortgage on it? What do all these things look like? And people often say, well, does that really matter? Because Shirley's still alive. The kids are still living there. It absolutely matters. And a lot of people don't realize is, which again, our next session will also talk about some details of tips and tricks you need to know. But a lot of people don't realize is Mom Shirley is on the house, but Shirley doesn't have any credit because all of her credit cards were joint and supplementary cards to Ken. So all of a sudden it's like Shirley needs to go in and the bank starts making the phone calls to us usually first because they're like, ugh, this client of yours or this person of yours doesn't have any credit. So this is something that we've really been working hard on people to understand is that, you know, those supplementary cards don't give you credit. And if you have no credit, you have no bank accounts besides the ones you have, those bank accounts get frozen. We have to notify the banks of all their accounts. So all those accounts that are with Ken get frozen. Anything that's joint with Ken and Shirley, you can still use, but they do document that value, as well as Matt also needs to document that value at that day of death. So we usually go in and we try to collect as much of those assets as we possibly can, get those people to come in and see, you know, we'd get Shirley to come in and see Matt and sit down as soon as they felt comfortable doing that as well. And we'd start that whole process. Matt would go through the probate process. So once we got the will, we'd obviously talk to the funeral home about getting certificates, and we need enough death certificates to actually cover off all the things we need to cover off. So oftentimes funeral homes provide 5. Sometimes they say, you know what, we can sell you a package of 10. Sometimes we'll sell you certificates at $3 or $4 a certificate. Those are always great things to know when you're talking to the funeral home, because some really do charge per certificate, some do not. Matt oftentimes has, you know, certified some of them for us because of the fact that it's actually cheaper sometimes to get that done, or more efficient sometimes to get that done, than even going back to the funeral home who huffs and puffs about trying to get those extra certificates. So sometimes people pre-arrange their death, and as well, they haven't thought about those things, and then all of a sudden the funeral home is out of business and you're trying to find plots of land or who they're now transferred their business to if they have. Sometimes that's not always worked out, but a lot of times it really has, and people, you know, have sold their business to somebody else and it's, you know, all registered and it's been done properly. And so Matt, like when you talk about probate, why don't we talk about probate for a couple minutes, what that looks like?
Sure. So for a situation like Ken and Shirley, if we have just Ken going, there may not be probate at all. It depends on how everything is held. So let's say Ken has all of the shares in his consulting corporation. We wouldn't need probate for that, because we would have a will and proof that Shirley is the executor and beneficiary, and we could transmit those shares over. With the property in Alberta and the property in BC, again, let's say they're jointly held, we would just transmit to their surviving spouse. In Alberta, very easy. In BC, also pretty easy. And there wouldn't be a taxable disposition there in BC, because oftentimes almost everything under the sun with relation to property in BC is going to have a little bill from it, from the BC government. There wouldn't be land transfer on that. Now, let's say Ken owned the property himself. In Alberta, we'd need probate, and in BC, we'd need probate. So how we would do this is we would apply in Alberta first, and then once we have our grant in Alberta, we would take a certified copy of the grant to BC Council, and BC would apply for a reseal, because BC land titles won't recognize an Alberta grant to move property and vice versa. So there would be 2 hits on that. Then there would also be a tax bill on that, because there would be a disposition from one owner to another owner. With the assets going to Shirley, again, if the bank accounts are all jointly held, then it's tripped to the bank with some death certificates and maybe a copy of the will, and then that gets sorted out there. If they're in Ken's name, again, they need a grant to show that they are correct in moving the assets over to the beneficiary, or rather to the executor, and then the executor to the beneficiary. So what is probate in a nutshell? Probate is the legal verification of will. What we do is we ascertain all the information that we can get on the deceased, on the executor, on the beneficiaries, on all the property that constitutes the estate. And when we say that, we include everything that quote unquote falls into the hands of the personal representative at death. This does not include any family trusts. This doesn't include property and joint ownership. This doesn't include RSPs or RIFs that are designated to a beneficiary that is not the estate. It would include it if the estate is beneficiary. Same thing with proceeds of insurance and proceeds of pensions. If there's a designated beneficiary, it's outside of the hands of the personal representative. If the estate is a designated beneficiary, then we would include it. Important note with RSPs and RIFs is even though the money went outside the estate, the tax bill may still be in the estate, but that would come later in the process. What we do then is we'd ascertain if who benefits, who should have benefited under law. So that may be if we have a situation with spouses who aren't named in the will, then we have to give them notice of what their entitlement would have been under the estate. We would then do a service of documents to all the relevant parties. We'd file at court, we'd receive our certified or our grant, or we receive some questions from the court. We'd answer those additional questions, and then we would receive our grant.
Perfect, thanks, Matt. And that's the thing is we need a full listing of assets. So a lot of times that's why we get people to fill out our What Matters Most books, be part of our wealth legacy model, just so that people actually have that on file. They have where everything is, because the biggest daunting task is finding where everything is finding what they have for their group plan, finding where it is, how it is. And we often hear from people as they get older, they're going to diversify out their banks. And so all of a sudden they've got a GIC at one bank, they've got a bank account at another bank and a savings account at another. We have to notify all of them. So it just makes it so much simpler that if you deal with one bank, one advisor, and actually have it simpler where we can actually ascertain where all the investments are, what they're doing, who the beneficiaries are, and be able to get those values to Matt to be able to do what's called an NC7, which is just an asset listing that both him and the accountant use at the end of the day to determine what the values were of everything that they need to do for the final return and for closing off the estate. So that's something that obviously we work with. We work with the banks to go through all of that as well. And we've even sat down with a lot of our clients because they get overwhelmed by the bank, or the bank comes to them and says, you know what, there's a $50,000 credit card. You know what, there's $50,000 and $500 in the bank account. We're going to take that $50,000 and pay off that car loan and the credit card. And that's not always the case that they need to do that first. So usually we get involved with the banks to leave some of the assets, make sure the funeral arrangements can get paid and things that are necessary to get paid. Because all of a sudden, if Shirley's not working and she all of a sudden has to pay these bills, it's like we've got to make sure that the house bills still get paid so that the gas is still getting paid and the electrical to keep the house running as per normal. So we usually go through the estate account to do that. We ascertain where everything is. We go through where everything is. We get valuations if we need it on the property and get valuators to come and assist with all of that. And then we transfer that all over. Our first call, of course, always is to notify people to get the insurance, also to do all the government applications of CPP, notifying CRA, making sure the social insurance numbers are closed down, because of course now it's quite a practice for a lot of the scamsters and fraudsters out there. As soon as they know somebody's died, especially when they're in the obituaries in the newspaper, that's when all of a sudden Ken starts showing up with all kinds of credit and all kinds of things that they've now created for Ken. So that's another reality that is starting to happen. Then, of course, too, we talk to people about what social media accounts, what work accounts did you have online? What kind of programs do you have in place? And a lot of people, you know, and again, we're going to talk about that in our next session as the details around that. So a lot of people don't even know Facebook has their own estate plan on there. And if you haven't filled it out, they're not really congenial, as even me and Matt are finding out on a lot of estates. They're not congenial at changing a lot of it without you initially going in and doing it. It's quite a process to even get some of these things shut down nowadays. So, you know, there's even creepy, I always tell people this story, which we'll discuss in the next one too, but there's even creepy things that you can do that send your spouse a love message every year on your anniversary, even though you're passed, which I think would cause some serious psychological issues, but people still do it. And there's that option available to you. So, that's something that you probably would want to discuss with each other ahead of time, because some people are like, I need this to be gone. I need to change my email. I need to change my life just because of that. So those kind of things are really important. So we kind of go through that whole process and then make sure that we get all that asset listing to Matt to work on, and go through, now what does the will say? What do we need to do with all these pools of assets? And the insurance will often get paid out within 3 days, 4 days. That's usually your biggest source of cash. And then it comes down to, where are we doing all that? Everything goes into an estate account until everything's solved with CRA and Revenue Canada. And then we do that. But Matt gets all the listings that he could do it all up, and then we talk about, where is it all going? What is happening with it? Where is it all going? If it's going to the spouse first, okay, do we need to do some updating on the spouse's will? Things like that as well. And then everything then can go to the accountant. Do you want to talk about some things in between, Matt, before we get to the accountant?
Oh, sure. And I just also, to your earlier point about Facebook and whatnot, I think it's a really important thing to note is, while, a good will have what we call a digital assets clause, and kind of talk about the right of an executor to access to email and online bank accounts and social media profiles or whatnot. There is a conflict of laws situation there. So does Apple have to follow the provisions of Alberta law when they're governed from the state of California? Questionable. So that's where it's useful to, be aware of some of the things that Pam noted, where there is that sort of a state option within Facebook, and with things like Bitcoin, we'll often get the question of, how can I govern it? And it's, well, good question. It may not be governable by Alberta. So it may not be governable by Canadian federal law. So what can we do, and do they have to follow our directions, is always a really big thing. When it comes to where we transition from what we do to where the accountants come in, it depends on the situation to a fair extent. So let's take Ken and Shirley here. Because we've got our consult co, I would say we'd want the accountant involved relatively early on, even necessarily before we file for a grant, because life is going on for this corporation right now, but the executor has a duty to, because they're now the shareholder effectively. So they have to make sure, usually in these situations, Ken would have been the sole director, sole shareholder. Thankfully, there's a will, because if there wasn't, it would be leaving a sole mess. But what would happen here is life's going on. The corporation may have a year end, and we have to be very concerned about the situation on the corporation side, because now would be the time we start thinking about tax planning. If we were going to do what's called a 164 sub 6 loss carryback, that has to be done within 1 year. And you're not going to go to an accountant 11 and a half months in going, hey, I just got my grant, can we do this? Because once the blood returns to their face, they will say, we'll try, but you'll get a bigger bill than you would have before, and a bigger chance of mistakes than you would have had before. Alternatively, there's other ways that we may go about it in that situation. We may do what's called a pipeline transaction, which effectively we pay the capital gains, but we don't pay the deemed dividend. The other way is you pay the dividend and not the capital gain. But long story short on that, you'd want the accountant in there early to ascertain the benefits and ability of doing either one of those plans, or hypothetically a different plan, or neither of those plans, depending on what happens with the Income Tax Act. Where we wouldn't have a consult co, or corporation, or a family trust, or a partnership to also be thinking about, in a conventional personal tax only, the tax return has to be filed. Typically, it's the following April, just like it would individually, except if you pass away near the end of the year, in which case, if it's November, December, I believe October as well, it's 6 months after in the next year. So it would be for, let's say, in 2020, if you pass away in November 2020, it would be May is when you would file, assuming normal circumstances, unlike this year. So you would want your accountant engaged possibly before we have the grant again too, depending on circumstances in the estate. So they should be involved relatively early on in the process, but they would in almost every case be the third stop after your advisor and your lawyer.
That's awesome, Matt. And that's the thing, is there's a lot of little niggly things in between that, like things like cars, or people often ask, wow, you know, we bought the car inside the company, how do we get it out? So that's something that the accountant kind of starts working on. Or there might be, like you guys said, is all of a sudden you have to go to a registry, because now that that person's passed away, if that car was registered solely in Ken's name, there is no bill of sale. There is no bill of sale to you. You have to end up taking a probated will often to a registry, and sometimes they won't even act on it because they want the lawyers to do up. And we've had that circumstance, Matt, a few times, where they actually want the lawyer to do up like a legal buy-sell agreement, almost like a purchase agreement to the executor, and saying the executor had rights to this vehicle and it was allowed to be transferred to the wife, which then costs you a whole lot more than it would have to register that vehicle that way in the first place. So that's why I mentioned those kind of things, and things like, you know, joint accounts versus sole accounts. You know, those sole accounts turn into estate of accounts, and those are the ones that we're going to try to draw money out of. But those are the ones that are frozen until we decide to actually solve them. Like Matt was saying, a lot of the RSPs can roll over, a lot of the TFSAs roll over, but I've even seen people set up TFSAs at a bank, and they've set up a beneficiary to be the spouse, but they haven't set up a successor owner, which means your TFSA room doesn't move over to the spouse. And so all of those little things that happen, or you may have named some charities, and we need to kind of involve some of the charities in that, because you want them to know the family, and you want them to know what the family's wishes were. And hopefully all the way along, you're having family meetings with those charities and kind of saying, this is what my intention is with this money with the charity. And that's where we get everybody involved with all of that. We get realtors involved if there's, you know, decisions to sell the house. But, you know, again, we usually advise not to do anything in the first year, just because a lot of times people regret it, or they sell a car and they go, geez, I wish I had kept that. And a lot of times you're not really psychologically ready. And we usually find people regret those decisions. So we often say, do nothing for the first year. And that's okay. It might seem annoying, but you know, a lot of times people are very thankful that that's happened. So,
and I think you bring up a really good point. You know, there's a lot of cases throughout the estate administration process where there's the right thing, and there's the right thing that somebody behind a desk thinks is right. And Pam and I encounter this all the time with banks, with registry agents, with land titles, with everybody under the sun, where they you know, a lot of times it's born out of, frankly, ignorance, but they think that they need to have certain things. And if you haven't been through the trenches before, you don't know when you can call foul on what they're saying. So the registry agent one was a really good example. I don't think I've ever had to draft up a buy-sell agreement for a vehicle between a husband and wife or anybody like that, but we've certainly been asked to do so, as Pam pointed out. The reason we didn't end up drafting them is because there's absolutely no way we need to do that. So what we would often do as a solution is, you know, it maybe go to a different registry agent, or we you know, send them with a letter saying, this is what the will says, just do it, or we'll sign the back of the bill of sale and toss it through and see what happens. But without, you know, the benefit of experience, you don't know that. And so you may go to some lawyer, get them to draft up a buy-sell agreement, get a bill for $1,000, maybe $2,000 or $3,000, depending on where you go, for this 2-page document that really wasn't necessary under law and really wasn't necessary for them. We see banks do a lot of silly things like that, where they ask for levels of compliance. I was advising a friend in another province where a bank asked for so much information and put so many restrictions on what was going on with money that it wasn't even them as lender, that they may have breached, or they may have, I don't want to say breached, but they may have created a situation where they prevented a closing and may have created liability for themselves because somebody at the branch level didn't understand. So it's really important to keep an eye on those types of things.
Yeah, and really important even from a bank, you know, we don't have her on the call today, but I'm sure she would have talked about it. Maybe we'll get her talking in a future session. But where a bank actually followed her child around when her father died because they thought that she had taken all the money and the mortgage was ending up foreclosed on because it had to be in bankruptcy, and they followed her kid at school, you know, and there had to be cease and desist from lawyers to get that to stop. So the reality of what some of these situations can look like are far more ugly than what a lot of people think. And if you haven't done it properly, or we've seen people go into banks and, like I said, they pay off all the debt instead of keeping any of the assets, and they don't need to do that right off the bat. And a lot of them, they try to protect themselves. They're not there to protect you or deal with the assets. It's like, oh, these assets are here, let's take this now, and we've protected ourselves and protected the branch interest, because sometimes they've overlent or whatever, and sometimes you're not obligated to pay that. So until you've been through the trenches, like Matt was saying, there's a lot of things that come up with that, and we'll
And I
discuss
think that's a
those things.
really good point. I mean, if there's one really good takeaway from that, it's, you know, they may be friendly, but they're not your friends necessarily. They want to have the same result as you, which is to get the task completed. But how a bank or how a registry agent or how you know a shareholder, not a shareholder, but like a transfer agent may want things to happen. May not be in your best interest, it may be in their best interest. And that's where, you know, having professional advisors is helpful, because we can kind of wade through what they really need and kind of streamline it.
Okay, well, let's get into the question and answers. Everyone can go into the chat and add in their questions, answers. There's a question answer block there that you can go in and ask some questions. You know, we want to be cognizant of time, because of course we know we're kind of at that time limit now. So if you end up needing to exit, you can go ahead and do that and let us know if you have any questions, and we'll make sure that we answer them here.
Thanks, Pam. So our first question comes from Brad. Brad's asking, what are the ramifications of interprovincial executors and or lawyers? Should one reassign the executor if they move out of province?
Good question. What's the ramification? Well, on their face, anybody who's not resident in the province of Alberta is considered a foreign personal representative. Sounds daunting, could be daunting, but in most cases it's not. What this requires them to do is to put up a bond or a policy for the value of the estate less any amount that the court says they wouldn't need to. Purpose of this is to have recourse in the jurisdiction, but I've been doing this for several years. Some of my colleagues have been doing this for decades and decades, and I've never had to apply for a bond. It's almost always waived. So once you have that waiver and you've applied and you're granted the grant of probate, it's business as usual. Where does it become a problem? Well, some jurisdictions may have rules on who can be an executor. In Alberta, you know, that's our rule is anybody can, as long as the beneficiaries and the court are effectively okay with it. In other jurisdictions like Florida, you have to be a resident or a blood relative. And this can cause problems even for professional executors like trust companies. So you would want to kind of make sure in every situation that you're covered on your known assets. I wouldn't necessarily remove an executor just because they move provinces. If that's the best person for the job and that's the person you're comfortable with, you know, the proximity becomes a secondary consideration if in exchange you're appointing somebody who, you know, isn't your first choice, may not be the best person for the job, or you may, you know, have to appoint a trust company or a professional. Then it's, well, is the cost justified just because somebody lives in Saskatchewan or BC? And I guess for other jurisdictions, it would really depend on the rules in that jurisdiction. But between BC and Alberta, I've seen executors between the two provinces without problem.
Thanks, Matt. Next question from Brad. Do assets such as RSPs and RIFs go directly into the estate account, and do they continue to grow or decline as market conditions dictate, or are they frozen automatically? is there a need to define this provision in the will?
So Pam, you want to touch the financial part first, and then
Sure.
I'll get into the legal?
Yes, definitely. Like once those assets are actually designated, what happens is yes, that still stays in an account. Like if you have an investment account, that still stays in the investment account to make or to lose money. Oftentimes, we often say, you know, if you can't afford that gain or that loss until we settle those investments, that's when we sell them, we settle them out of the estate, then they actually get cashed. Some people, you know, you can transfer that into money market, or you can transfer that just into a cash account. That's completely allowable. But yeah, so they still move and do everything that they did prior. And then Matt can kind of talk about the provisions of what can happen in a will or not.
Right. So in a lot of cases, we'll have a clause that designates a beneficiary if a beneficiary isn't already designated in an RSP, or to designate what the estate does with that money once it's entered into the estate. So typically, a proper tax-deferred assets clause would allow for all the flexibility that Pam described. It would be unusual to have a clause that would have specific instructions on it, because those instructions may be well-intentioned and logical at the time of drafting, but at the time of administration may be extremely bad. So we tend to leave it relatively broad, except to maybe direct where proceeds go. And even directing proceeds can be, it's typically net proceeds after all the debts, taxes, and obligations of the estate have been dealt with. Because if you have a situation where an estate is an RSP proceeds and house, and we've got taxes to pay, we're not just going to send that money over to the beneficiaries. It'll be the net proceeds after we've paid off the debts and taxes, because it's the easier thing to distribute. Of course, that depends on how the gifts are made. That's just assuming everything's in one pot. If it's specific gifts and residual gifts, we get into marshalling, it gets a bit more complicated, but generally it's a matter of keeping it flexible while directing the end beneficiary.
And of course, when there's beneficiaries on it, that's something to know too, is that most of the time when you have an RSP or a TFSA or even a pension, we usually can get that rollover done within the week. And you know, that's pretty brave of us, but I think I've seen people not be able to do it for months, but we usually can get those rolled over within the week to the name that they're supposed to be in.
Great, thanks. Next question comes from Peggy. How do we get our vehicles joint registered if they are registered in a single name?
You just need to go to a registry and basically go and tell them that you want them joint registered. And usually, sometimes they do it under the same payment that you've paid for your registry initially, and some will charge you a $50 charge to change that.
Thanks, Pam. Next question comes from James. Many say this is overwhelming. How can I make it as easy as possible and prep in advance?
So things like how we discussed, you know, like I think sitting down, going through our wealth creation system, and our What Matters Most binder, we've always prepared people for all these type of things, making sure people are on our legacy model, making sure that they've actually gone through and they fill out all those documents. It will cost you some money up front, but of course it always saves you some money on the back end in a big way. So we always try to make everything easy for people. You have it in one place, one binder. We have a whole system that works for all of that. Making sure that you have an excellent will done by Matt. You know, power of attorney, personal directives, really important. So we make sure that those documents are all done properly ahead of time, making sure that we've actually sat down and gone through this whole estate process. As you're seeing, it is a process. You know, and it's oftentimes people forget about this process and kind of go, well, what are my investments doing? What are the return on my investments? And it's like, that's such a small part of your whole overall plan. Now you're kind of seeing why that we say that. So, you know, at the end of the day, nobody really cares about that when something happens, you know. So, you know, you want to be organized and you want to do that ahead of time, and making sure that you are organized and not over diversified, not leaving accounts. We've seen people leave their employers, or some people have had a new employer every year and they leave their accounts there. And they're like, well, I'll get a pension later. And it's like 10 pensions later. A lot of people can't keep track of all that. They haven't kept track of them all from taxes or different jurisdictions. And it becomes a mess. And it's a real mess to try to settle as well.
Absolutely. I think keeping it simple is always a good thing. And I think what you want to do is something like the Willing Wisdom Index is very useful in kind of getting you focused on the types of things to be thinking about even before you come into the office of somebody like me to do estate planning. I tend to recommend having versatile plans that can adapt to your life. One of the things to be really aware of is when you're doing an estate plan, watch how many specific bequests and specific gifts you're making, because a lot of times people forget about those, that they made those requests, and they can really complicate things later. You may have the situation of duplicated gifts. You may have the situation of something not being in existence anymore and having to address that. And that adds a layer of complication to things that ought not to have existed, or forget about their executors and forget to revisit it. Like I said in a previous webinar, it's not like going to the dentist that you have to go every 6 months, but it's something that you do want to be aware of what you've kind of put down, and to be proactive on your investments, to be proactive on your estate plan, and make the little small changes when you need to. So making sure designations are up to date, making sure your asset mix is reasonable, making sure you don't have too many loose ends, making sure that your will or other estate documents are amended or redone when there's been a change, if you've been divorced, if you've changed significant properties, if your beneficiaries are different, because that all makes things easier later.
Thanks, Matt. Brenda has a question. She's asking, what's the best way to start this chat with my parents?
Well, that one's a really interesting one, because of course, I've had a similar situation even with my parents. I think parents, especially from the baby boomer generation, they don't like to discuss that kind of stuff with their kids. And I think the way they were brought up was always, you don't discuss that kind of stuff. And I don't know how many times I've heard, we've got it handled. We've got it handled. And then the kids come in because one's sick, and you see wills that were 25 years ago, 30 years ago, bad tax laws. They haven't taken into account a lot of the things that we've talked about in our previous webinars. So if you haven't seen those, please, look those up as well. But I think really it's saying, as part of your process, as part of your estate planning process, this is something that can be in a service from us, and saying, they can give you a second opinion process on this. And then we can at least review it, give them some input that's not coming from you, because that's certainly helpful. And I think, looking at letting them make some decisions, letting them go through, you can give them some information, we can give them some information. You can give them a book. Once we've seen people actually fill out their own What Matters Most book with us, usually the parents are like, well, I need that. I want that. Oh, you got your will redone? Well, I should look at mine. So usually you're that good example for your parents that you can tell them all about it, and then usually they want to be part of it, or they can come see us and come sit and do that. And Matt will actually look at that too. We've had many family meetings with parents too, and then involved Matt in trying to get the wills rewritten and involve that. He's got a meeting even with a client at the end of the month that's exactly that, where they're bringing in their parents again. So that's a good thing.
Absolutely. And I think it's one of those things, your mileage will vary a little bit on what will work best for your parents to get them intrigued with the idea of refining their plans or building up a plan. Some people react well to the cautionary tale. Some people will get defensive by the cautionary tale. And it may be a situation of talking about making sure that they're taken care of for incapacity, because a lot of people just think of a will and that's it, and then they're done. And really, there's way worse things than death when it comes to estate planning, and that's incapacity without adequate protections in place. So it'll really depend on what resonates well, but you really need to have open communication for estates to work properly, and for intergenerational wealth and transfer and succession to truly work. The age of keeping things shrouded in secrecy is the reason why there's so much estate litigation.
Exactly.
Thanks, Matt. So one more question here, and then we'll end it off for today. So
Perfect.
Nancy's asking, should you make burial arrangements ahead of time?
That's a question we get asked a lot, and I'll give you my opinions, and then I'll maybe give it over to Matt too to get his. I think what I've seen is some really excellent work done ahead of time. Just make sure that you've done all the planning. So, like, if you're going to have a tombstone, make sure that tombstone's available. Because a lot of people buy tombstones, and then when it comes down to it, that's not there, and the family ends up having to do a lot of stuff. Maybe do that work ahead of time, or have names at least printed on them ahead of time. And then they can always put dates and messages or things like that on them afterwards. So a lot of people arrange for one and then it's not there at the end, or they can't get similar type things. I've had people arrange for pieces of land, and then of course that garden becomes full because they haven't taken into account the ones that they've pre-sold. That's happened, and I'm not sure the legal precedents around some of that. Which Matt will be able to answer, but there's some of those issues that have come up, as well as companies getting sold, and then people are like, what now? So it's just making sure that you're with a lot of the bigger people to do it, and making sure that you have everything that you want done.
I would agree with all of that. I would say if you have the appetite for it, because a lot of people don't like the idea of planning their own funeral. I think it's a really good idea because it's one less thing for the family to have to deal with. It's one less thing for a family to argue about if you have views that aren't shared with the rest of your family. And I've had a couple situations like that where their family would have insisted on being buried in a religious tradition, and that person didn't want that. Then having it pre-planned and having something your executor can just go with and roll with your signature on the bottom of it is a good thing. Cautionary point on that though, make sure your executor knows, because I've dealt with a couple different times where 2 funerals were booked, and fortunately once was with a trust company and they had the connections to get rid of it and not have to pay anything extra. But that may not be the case for your executor. They may go somewhere and they may spend a little less money and have it non-refundable or something like that. So make sure your executors know, and like Pam said, go somewhere reputable and find out what their contingency plan is in case the home is bought out or something happens.
Excellent. Well, thanks everybody for attending. Can't wait for you to watch our other webinars. If you haven't watched the Willing Wisdom webinar, that was actually the first in our state series. You can go back and watch that one that Matt was referring to. And of course, we definitely recommend those because, it gives you a great place to start and have a conversation about what you still need to do, have a conversation with us about what's still outstanding. Those type of things. And then of course, our next webinar will be discussing some of the ins and outs and tricks and traps of this trade. So we look forward to it and hope to see you there.
Thanks for having me.
Thanks, Matt.